All right. Hello. My name is Noel Bagwell, and if you're tuning in for the first time, what you need to know is I'm an attorney licensed in the state of Tennessee, and I've been practicing for, I guess this will be 13 years in April. And I have a I have something I want to talk to you about from just the perspective of an attorney who's troubled by how little access to justice there is. Actually, I frequently get prospective clients, leads who come through our firm's pipeline, and they are looking for an attorney, and they can't really afford one, and that's a problem. Not just for us, not just from a business standpoint, not just because lawyers want to make money, but I will give an extensive, um, in-depth, detailed legal consultation at no charge to a lot of these clients, almost all of them, really. I'm not I probably don't guard my time as well as I should when it comes to doing initial consultations, especially if the client has what appears to be a real need, like a real need. Um, I recently had a consultation with a person who had been the victim of a false arrest report. A business um, had this person arrested, claiming that they stole a vehicle across state lines, and that just wasn't true. And the business um, didn't even check. They didn't even check to see whether the vehicle had been returned before they filed the false police report. The vehicle had been returned, and the person who was arrested, um, in fact, had been in constant communication with the company. I'm being really careful about what I can say because um, I don't want to, destroy attorney-client privilege. There isn't any because I didn't give the person, I didn't create an attorney-client relationship with the person in the course of this consultation. I listened, um, and it's stuck with me. Like this is the amount that they could sue for is greater than $75,000. There is diversity jurisdiction, so this could be a federal lawsuit. And the person lives in one state, the business is in another state, so they could literally make a federal case out of this. The problem is though that despite the fact that this arrest cost a person a new job that they were about to start, cost them significant income, wrecked their life, has caused them serious distress. I won't get into all of it, right? But suffice to say, this one false arrest ravaged their life, and they can't afford to do anything about it. I wish this was like an isolated thing, but I get these kinds of calls all the time. I get calls from people all over the state and sometimes from around the country, or even very rarely in other countries. I get calls from people or emails from people reaching out for legal help, um, and they can't. They have legitimate concerns. They have legitimate cases, and they can't afford a lawyer. And this is such a problem. And the problem is that they can't afford the lawyer on the front end, and lawyers aren't often equipped to, front the cost of legal fees. Lawyers can't afford to pay up front all the cost of a client's case. So what do you do? Um, Litigation financing is kind of an emerging thing where you can finance your lawsuit, but typically those are for very, very large lawsuits, often complex litigation like class action lawsuits and that sort of thing. And so you don't really see that on the lower end where there might be $100,000 or less in controversy in dispute. So what do you do? What do you do to expand access to justice and to level the playing field? Um, you know, I don't want to believe that we don't have a justice system. I don't want to believe that. I don't want to believe that we just have a legal system and that you get as much justice as you can afford. I don't want to believe that. I didn't go to law school for that. I want to help people and I want people to have access to justice. I want every single person who has a legitimate lawsuit or dispute to be able to go and hire the lawyer of their choice, the lawyer that they really believe would do the best job, pay that lawyer, make sure the lawyer gets paid, gets fairly compensated, that they're appropriately invested in the work, and then I think it would be fair that whoever loses in that courtroom battle pays the cost of all the litigation. I've been thinking about how to fix this access to justice problem. I've been tinkering with this idea, and I've written a white paper that I think provides a solution. I'm not saying it's the solution to access to justice. That would be arrogant, but it's a solution, and it's not a perfect solution, but I think it's far better than the system we have now. So I've written this white paper. I posted it on Substack. I'll put the link in the description of this video. We're already like 6 minutes in, and I'm kind of bearing my heart here a little bit. But I do want to get into some of the details of the proposal a little bit, and just kind of quickly go through the white paper in summary fashion. I'm not going to bore you with all the details or make this 90 minutes long. I want this to be reasonably digestible. But if you are interested in the details of the proposal, it's posted on my Substack for everybody to see. So just jump on there and check it out. So here is what we've got. This is a proposal for reforming access to justice. And what I would propose is a court supervised fee system with a loser pays model. Now, couple of quick introductory ideas. We already have loser pays, but only if you can contractually agree to it or in a fraud context. The American rule about attorney's fees is everybody pays their own lawyer. If you commit fraud and you are sued by someone for fraud, then the winner, the victim who wins in their lawsuit against the person who committed fraud, is entitled to their actual damages or consequential damages, all of that, plus treble damages and attorney's fees. So you can win your attorney fees in a case for fraud. Also, if you're suing over the breach of a contract and that contract contains a provision that says something like, in a lawsuit arising out of this contract, the loser must pay the winner's attorney's fees, or the winner is entitled to collect from the loser their attorney's fees and reasonable costs of enforcing their rights under this agreement, something like that, right? There are different ways of drafting the attorney's fees provision. You'll see in a lot of contracts, like residential leases and stuff, pretty commonly, that only one party's attorney's fees are discussed or mentioned in the attorney's fees provision. So remember, the default rule is everyone pays their own attorney's fees. If the attorney's fees provision says something like, in the event that we have to sue you to enforce our legal rights under this agreement and we win, then you must pay our attorney's fees, and it doesn't say anything about your attorney's fees, then that's pretty one-sided. It's still enforceable, but it's not a true like loser pays situation. So we do have loser pays, but it's very limited and it's not the default setting. In other jurisdictions, in other countries, loser pays is the rule. Like whoever loses the lawsuit has to pay, the legal fees of the winner and the court costs and all of that. And this loser pays system makes people really think, well, if I don't win this lawsuit, then I could get stuck with the other guy's legal bill. And so you really do a cost benefit analysis or a good thorough risk analysis before you risk running off to court. That's good because it makes people really think twice, and it makes them be careful, and it takes like frivolous claims or borderline claims out of the court system, or at least it creates incentives for them to settle those kinds of claims. So that's a good thing. Loser pays is a very, very good thing philosophically. From a legal philosophy standpoint, it's desirable, but it's not what we have. It's not the system that we presently have it by default in the United States. So I think that's something that needs to be reformed, and I think we should reform it at a state level, not the federal level. So I think states should start adopting a loser pays system more broadly. Um, I think you can do it in a way also that's optional as part of this access to justice proposal, and pair it with a court supervised fee system. This is also not incredibly novel. The combination of these things is novel, is very new. It's a new idea. At least it's new to me. I've never heard of anybody else suggesting what I'm suggesting, but the actual court supervised fee system is in place already for indigent defendants. An indigent defendant is a person who is accused of a crime and represents to the court that they cannot afford a lawyer. Part of the Miranda rights is, if you cannot afford a lawyer, one will be appointed to you. Under the Sixth Amendment to the U.S. Constitution, you have the right to counsel, et cetera, whether or not you can afford it. So, you do have the right to effective assistance of counsel. And so, the court currently has a system where an attorney can sign up on a list, to take court-appointed cases. And if the public defender is overloaded, their docket's already full, their caseload's already full, and the system basically will allocate a defendant to an attorney who's on the list. So then the attorney will submit their bill to the Administrative Office of the Courts, the AOC in Tennessee. Now, different jurisdictions may be structured differently. I'm licensed in Tennessee. When I first started practicing law and I had no clients, I got on the list and I started taking court-appointed criminal defense clients. That's not what I wanted to do in my career. I don't do that anymore and haven't done it for a very, very long time. But I remember when I was first licensed, that was, how I got some courtroom experience. I, made a little bit of money, not very much money. The billing rates were very low. It was $40 an hour out of court and $50 an hour in court. So we're talking very, very low rates. So, and you submit those bills, the lawyer submits the bills to the AOC, the Administrative Office of the Courts, which is under the Tennessee Supreme Court. And they will review the invoices and they kind of, I don't want to say audit each one, but they review each one along with your expenses. So you have your hourly billings and your expenses, and they will either approve it or they push back on it and go, I don't know about this, or this seems inaccurate, or did you really spend this much time on this? Anyway, there's some review and there's some accountability there. So if you're not doing what you ought to be doing in terms of your billing practices, the AOC can push back on that. If they do approve your bill, if they say, oh, that's pretty reasonable, it seems like you're within the normal range, or whatever it is their criteria is, that I never really looked too deeply into what criteria they use to review the invoices. But if they approve them, they send you a check or direct deposit or whatever, and the attorney gets paid. So my proposal largely is to have a system whereby every single defendant, whether they are, or not defendant, every single litigant, plaintiffs, defendants, in defendants in civil cases, defendants in criminal cases, and even the state can elect to participate in an equal access to justice program. The state would kind of automatically opt in a criminal case if the defendant opts in. So if they opt in, then the state's like kind of automatically in terms of opt-in. So what's nice is that this system would be entirely optional. It would just be an optional path. It would never be mandated. It does nothing in terms of changing the public defender paradigm. It doesn't take any money away from the public defender or any resources like that. Instead, it simply offers another path for litigants who either are borderline indigent or of just such modest means that they can't afford the kind of lawyer that would be necessary to bring their claims in court. For whatever reason, if a person believes I need to sue and I can't afford it, they could opt into this system. Now, it's a transformative legal reform model, right? And I will kind of read a little bit from the executive summary here just to present the way overall from 30,000 feet how it would work, right? This is designed to guarantee that every litigant, again, plaintiffs, defendants, the state, whoever, has genuine access to competent legal representation, regardless of their economic circumstances, rich or poor, you will be able to afford the lawyer that you want. And the current justice system is plagued by prohibitive costs and structural inequities. It denies meaningful access to courts for those without substantial financial resources. It takes a lot of money to sue. And I can't do anything about the cost of that, although I think this proposal could actually curb legal costs in excessive legal costs. And I can dive more into that a little bit further in. But generally, it's really about allocating the costs efficiently and correctly according to the dictates of justice, right? That's how this proposal works. The proposal seeks to remedy the systemic failure through a two-pronged approach. We expand the court-supervised legal fee system to include, civil cases, and not just, criminal defense cases. So we expand that, and then we adopt a loser pays model. The approach is not a perfect solution. I admit that there probably are areas where it will need to be refined and improved in order to get closer to perfect, but no complex human system is ever going to be perfect. And my argument to critics would just be that don't let perfect be the enemy of better. This system does reduce taxpayer burdens. It does promote meaningful access to private counsel, and it deters frivolous litigation through clear enforceable penalties for losing parties. And it is a penalty. So as we'll talk about further in, the court costs, the legal fees, all of that, everything in terms of the costs of a lawsuit becomes a penalty that is taxed to the loser in a lawsuit or a prosecution, and it's non-dischargeable in bankruptcy. The reason for this is it's important. The reason for this is that it's important not to stick the taxpayer with the bill, right? It's important to be able to have a system that generates collectible revenues for the state to pay for the system so that it can be revenue neutral, and that would be the goal, is revenue neutrality. And there would be, in terms of the fees that the AOC would assess for its services provided in connection with the program, there would be sort of this philosophical bias towards having fees set at a level that guarantees revenue neutrality and could produce a small surplus for growth of the program and expansion of it and so on. We're not talking about massive revenue surpluses, and we're certainly not talking about some sort of like profiteering. That would be against public policy and a terrible abuse of the system. That's not what the system's designed for. It's designed simply to make sure that anybody who has a viable lawsuit can actually bring that lawsuit. So, as I said, first, the reform would expand the role of the administrative office of the courts or similar entity, an analogous entity in a different state, with the responsibility of reviewing attorney fees and associated litigation expenses. The AOC would scrutinize invoices for reasonableness and compliance with ethical billing standards, and it would impose a modest oversight fee ranging from 3% to 10% of each invoice that it reviews from an attorney to fund its operations. And I have kind of a big, I know 3% to 10% is kind of a big range, but I don't think that you could do it for less than 3%. I think more than 10% would probably be unreasonable. But, based on data from a pilot program where this is tried, you could narrow that range down to a single percentage, maybe even to a fraction of a percent to understand like what the AOC would need to charge in order to accomplish the goals of the program. The oversight mechanism, which again is already in place, this is a system that's already in place for the indigent defense program. It's not a system that has to be reinvented from scratch. It's a system that already exists and would just need to be expanded to expand access to justice. This oversight mechanism provides a much needed check on excessive billing practices that can quickly escalate the cost of litigation, making it prohibitively expensive for many. Currently, some states, administrative offices of the courts or similar organizations have the similar function with respect to indigent defenses in criminal cases, as I've mentioned. So again, and I cannot say it enough times, this proposal would expand its purview to include civil matters and attorney fee review for all litigation in the relevant jurisdictions. And when I say all litigation, I mean all litigation in cases where people opt in to using the system. This new review role builds on existing ethical and administrative functions. This would require litigants to opt in. If you don't want to take the risk, you still have the option of just hiring an attorney. Just like criminal defendants would still have the option of using the public defender or using the existing indigent defense system. This equal access to justice program would only be used by people who, for example, don't trust the public defender or can't afford to hire a private attorney without using the system. So there is definitely more risk, as I'll dive into next, for people who use the system, because if they lose their lawsuit, then they'll end up paying the legal fees, the winner's legal fees. They'll pay their legal fees, the winner's legal fees, and they'll also pay the fee charged by the administrative office of the courts, which will increase the overall cost of the litigation by 3 to 10%. So there's substantial risk of rolling the dice on one of these lawsuits. It's not a good idea to use this program to try to do some sort of profiteering, or if you have a weak legal claim. If you have a weak legal claim, you should stay well away from this program because you will end up financially ruined, possibly. Um, the second prong, as I mentioned, is the adoption of a loser pays principle or program, wherein the party that does not prevail in the criminal or civil case bears the responsibility for all litigation costs. These costs, including attorney fees, filing fees, expert witness fees, court reporter expenses, etc., would constitute a non-dischargeable debt in bankruptcy because it would be considered a penalty payable to a governmental unit under 11 USC 523A7. This provision ensures that the victorious party is made whole and is not forced to shoulder the burden of litigation expenses when they have been vindicated under the law, and similarly protects taxpayers from bearing the costs of unsuccessful litigation. The loser pays framework also incentivizes litigants to carefully evaluate the merits of their case and may encourage more efficient use of legal resources. This promotes a more judicious application of legal process and could help to alleviate the pressure on courts by deterring frivolous lawsuits. By integrating these two components into a single unified program, the proposed framework aims to create a more equitable, efficient, and transparent legal system. It addresses the core problems of wealth disparities dictating legal outcomes and ensures that individuals and businesses are not unjustly excluded from the justice system due to financial constraints. The revenue generated from the AOC oversight fee would be reinvested into court infrastructure if there are any again, this is if there are any overages, if there are any surpluses in the revenue generated. It would be reinvested into court infrastructure, improving overall accessibility and the overall quality of justice. So, the funds would be earmarked and couldn't be taken out of the program or used for any other thing. It would go straight into the AOC and used for first, primarily running this program, the Equal Access to Justice program, and secondly, to investing in additional court infrastructure, specifically court technology infrastructure that would improve the efficiency and effectiveness of the program. This proposal's feasibility within existing constitutional and statutory frameworks is evaluated in the white paper, and its anticipated impact on affordability, fairness, broader social values are carefully examined. The proposal could be phased in via pilot program. So this is a practical proposal. It's not just some ivory tower, pie in the sky conceptual thing. It's not theoretical. This is something that a county like Davidson County or Knox County or Shelby County could implement. You could take this proposal if there's the political will to do it, and you could implement this via a pilot program this year, next year. I mean, very quickly. Again, the AOC is already there. You probably would need some legislature, some involvement from the legislature and the court. You certainly would need the Tennessee Supreme Court to be on board with the pilot program at least. There definitely are some political and bureaucratic hurdles to clear, but there's nothing that you would have to do really to like fundamentally transform the legal system, although this program would have a transformative effect on access to justice. So um, again, the proposal could be phased in via pilot programs. The pilot programs would measure the anticipated results. It would allow for sort of a laboratory, a workshop in which strategies for implementation with robust oversight could be carefully tested before wider adoption, like before sending it statewide. Potential objections to the proposed system also could be addressed in meaningful ways, not just to be refuted, but to inform a better approach with the goal of continuing the expansion of access to justice. So, this white paper posits that the reforms contained within it offer a viable pathway toward a more balanced and transparent marketplace for legal services. It aims to restore faith in the judicial system, which is crumbling, by ensuring that justice is not a commodity reserved only for those who can afford it. Again, I don't want to believe that. I don't want to believe that we only have a legal system and you get as much justice as you can afford. I don't. The goal is greater fairness, improved confidence in defense quality. Lots of criminal defendants, indigent defendants, they don't have any confidence in the public defender. That's a shame. And I mean, we can fix that. That's not something that we have to give up on, right? And the goal is also a balanced way to finance legal representation. It needs to be balanced. It needs to be fair. So I'm gonna just this is a 31 page or so white paper. It's pretty decently written, I think. It's clear. It's not too um, over the heads of most people. I don't think it's too wonky and from a policy wonk standpoint, but my forte in law school is economic analysis of law. So this is exactly the kind of public policy thing that I'm trained and educated and equipped to talk about. And it's a passion of mine because I cannot tell you over the last dozen and a half or more years of legal practice, I cannot tell you how many times I've had to accept that a person simply can't afford the lawyer that they need. I've had to, give people legal consultations, and accept that they are not gonna hire me, not because they don't want to, not because they don't have a case, but simply because they can't afford it, and there's not really anything that can be done about that. So, I hate that because that feels like injustice to me, and I despise injustice. So I do want to kind of just quickly go through some other little parts of this. The heart of this is that there is a crisis in access to justice. Essentially, legal costs are quite high. I do think that, as Deborah L. Rode has pointed out, the high cost of legal representation is the single greatest barrier to justice for most Americans. We're known for being a litigious society. We are known for being kind of a high conflict society. But listen, the court is the modern battlefield. I've explained to people who are in disputes that the law and litigation is a proxy for violence. Litigation is a proxy for violence. It is an inherently violent thing. It's the way civilized people resolve their differences without actual physical violence. Because if you can't resolve your differences in a civil way through presentation of evidence, arguing principles, having a system of rules that's generally fair to everyone. If you can't depend on that to resolve your disputes, many people will resort to actual physical violence. So the law and litigation is a proxy for violence. If you want a less violent society, you need to have a better way to resolve your disputes. If people give up on this, if they give up on the justice system, there will be more violence in society. If you want a more peaceful society, you have to have a more just society. You have to have a justice system, not a legal system where you only get as much justice as you can afford because people will check out of that system and then they will be violent. So it is a crisis. It is a social stability crisis. If the justice system crumbles and fails and confidence erodes and people believe that they really only ever get as much justice as they can afford, they will take justice into their own hands. So it's a problem that legal resources are unequally distributed. That it's a problem that there are justice gaps, and I'm not the only person who's aware of this. Like it's well studied. Um, it's known. This is known. This is a known problem. We know about the problem already. We've known about it for years, and we've known that because middle income individuals and small businesses, we're not just talking about the very poor and indigents, but we're talking about, people in the middle face prohibitive costs when they're seeking legal representation for everyday legal matters, right? Because we know that, how can you expect that if people in the middle, just normal people with everyday legal stuff, are having to forego legal representation, how can you expect them to keep high confidence in the justice system? That's not reasonable. Gillian Hadfield wrote, access to the legal system is rationed by price and availability, and the effects of that rationing are felt acutely by those who are not wealthy and do not fit into the categories of need that have prompted targeted funding for legal aid. So you essentially have people in the middle suffering more. People at the very bottom, they might have access, the very poorest people who have the most urgent needs, supposedly, may have access to legal aid society or special interest groups that are going to fund their litigation or whatever. And then, of course, the rich can just pay for an army of lawyers, and that's fine. Right. But what about all the people in the middle? What about the normal people, the non extreme cases? Those individuals and businesses may not qualify for legal aid, but they also can't afford traditional legal representation. So they're forced to navigate the court system without proper legal counsel or to just give up on meritorious claims. This is especially true for businesses. Most of my clients are businesses. So small to medium sized businesses have to give up a lot. Um, I will sometimes talk to clients about creative ways to collect on their debts. They one possible strategy for some very small, closely held businesses, like if you've got a limited liability company or something like that, or a small corporation where there's only a couple of owners, you might have like one or two owners. You might have an owner or you might have a business, the company who's owned a debt, um, who's owed a debt rather by a vendor or a customer. They might sell that debt, they might sell the right to be paid on that debt to a single individual, a natural person, a human, right? Not a legal person like a corporation or an LLC. They might sell the right to be paid. And then that private individual might go and present to the court their right to be paid. And they'll say, hey, I bought this right to be paid from the company that I own. Here's all the legal documentation showing that I own this debt now and I'm going to collect. I'd like to collect against this other person. And they do that pro se meaning without a lawyer. And the reason that they would do something like that is because they're desperate to collect. They need to collect. They want to collect, or it may not even be desperate. They may just not want to let it pass, right? I don't want to feel like I'm just being taken advantage of because the debtor believes that I won't go hire a lawyer. I won't go and pay more money, throw potentially good money after bad. They think, well, this is too small to litigate, but I don't want them to get away with not paying. So I'm going to bring this claim myself, right? I'm not going to go hire a lawyer. I'm going to take my chances pro se in court, right? They should never be put in that situation. They should never have to choose between justice and like having to like pursue that justice themselves. They should be able to hire competent legal counsel. and know that when they win, then the attorney's fees are going to be paid by the loser, which, absolutely just. So, um, when we don't have a fair, loser pays system, and when we don't have legal fees being advanced by, a party like the administrative office of the court, sometimes you get into a situation where someone has to say, "Well, I just can't afford a lawyer. I'm going to have to give up this claim," and that erodes faith in the judicial system, which can create at the margins a more violent society. So I think that's a terrible thing, and the basic principles that underpin this whole system are that we should have equal access to legal representation. There should be general fairness and more uniformity in legal costs. So you have to have an authority that sort of reviews and establishes what that is without price fixing, without, collusion and stuff like that. I mean, there definitely are pitfalls to avoid. You need ethical oversight of some kind, and prevention of fee abuse. But hey, we already have a 10-factor test for what constitutes a reasonable fee. Again, we don't have to reinvent the wheel here. It's not going to be a problem for the AOC to look at lawyers' bills and go, is that reasonable? Because we already have Rule 1.5 of the Tennessee Rules of Professional Conduct. I think it's Rule 1.5 also of the ABA model rules that governs the reasonableness of a fee. What makes a fee reasonable? We already know. So we already have an answer on that. All we have to do is apply it. We have to apply that test. And the more cases come through this kind of proposed system, the more data points you have, and the more you can further refine your understanding of what generally constitutes a reasonable fee, and also what would constitute exceptions to that. A big problem with determining fee reasonability or reasonableness is that there's not a lot of data on it because there's no mandatory reporting of fee structures and hourly billing to a higher level outside of a fee dispute or a bar complaint or something like that. So because there's a dearth of data in the system, we don't really have like a great sense. It's kind of the Wild West, and you charge what the market will bear in a lot of cases and stuff like that. So if we wanted to have more ethical oversight and prevention of fee abuse, then you're going to need to have a more data-rich system. And a secondary effect of the adoption of this proposal would be to create a more data-rich system like that. And you could have a streamlined financial administration of legal fees as well. So the approach actually does. I do want to get into this. People do kind of look at government providing services and extending oversight as something that might inhibit freedom in some way or whatever. But remember, participation in this program would be entirely voluntary. Like no one's ever going to make you do this or make you use this system. It's never going to become compulsory. The proposed system is committed to streamlined financial administration of legal fees. So under the current system, post-trial fee disputes can be administratively burdensome because sometimes you have like these proceedings in litigation where we talk about should the fees be assessed to the loser for one reason or another, and courts have a lot of discretion about that, and sometimes it's required under statute, or in the case where someone files a frivolous lawsuit in Tennessee, we now have a statute that takes discretion away from the judge and mandates that the judge award attorney's fees to a successful defendant in a case where a plaintiff has frivolously brought the lawsuit. We also have, fraud claims where attorney's fees can be collected from the victorious party if they're alleging fraud and a victorious plaintiff. We also have the Tennessee Consumer Protection Act, where a victorious plaintiff there can also collect their attorney's fees. And then we have the contracts where we have a loser pays provision that's been written into the contract. So there are these post-trial fee disputes that can be administratively burdensome. They can delay final judgments. And this proposed system simplifies and streamlines that process by integrating cost review into the litigation process in near real time. Because litigating parties who are submitting invoices for their work as the case goes would submit that to the AOC. The AOC would get those, review them, and be like, okay. And the AOC effectively would pay those invoices as the case goes on. They front that money, right? And they pay the invoices. They advance those legal fees to the attorneys throughout the pendency of the proceeding, and then at the end, they collect it all back along with their percentages and everything from the loser. And if the case were to settle prior to a final judgment or something like that, then pursuant to the settlement agreement, the settlement agreement's terms would dictate who has to pay back the administrative office of the courts, again, as a penalty, as a tax, and also pay the AOC's administrative fee. So it would incentivize people to settle quickly, to settle their claims quickly, because the more it drags on, the more expensive it is, and it's even more expensive if you're using this than the current system. So um, rather than waiting for the conclusion of the case for fee disputes to be adjudicated, the AOC or a similar entity would oversee the cost review process throughout the litigation process. And I say it would be more expensive, but when you introduce these kinds of efficiency processes, it's possible that this could even reduce post-trial fee contests and help facilitate more efficient final judgments and bring down the cost of the legal fees. Yes, the AOC's got a 3 to 10% fee, but if you're bringing down, overbilling by more than that, then they could conceivably even pay for themselves. It really depends on the lawyer and how much inefficiency or inflated billing the AOC catches. And they have an incentive, they have a powerful incentive to push back on attorneys billing too much, because the AOC can look at that and be like, well, we actually saved the public money. So they could generate some real ROI there. This would promote predictability of administrative efficiency, allowing for more timely and seamless legal process. And so the approach minimizes, actually, in the long term, bureaucratic red tape. And in a holistic view, it minimizes bureaucratic red tape and potential delays associated with the current system, especially in the post judgment fee disputes, while enhancing efficiency and transparency of the financial aspects of the litigation. In other words, the proposed system seeks to minimize the administrative burden on the judiciary while simultaneously improving the experience of both litigants and attorneys. So, criminal defendants and civil litigants both would if they voluntarily engage, and again, no one's making you, if they voluntarily engage with this process, then they'll be able to hire the counsel of their choice. Um, so criminal defendants, the one question arises in my mind, like, how would you really handle um, one litigant wanting to use this system and the other litigant not wanting to use the system? So if you have a civil dispute, um, you know, is it really fair for a plaintiff to use this system when the defendant is like, no, I just want to pay for my own lawyer, and I don't want to accept the cost shifting aspect of this? Like, that's the single biggest concern that I would have about this system. But I think as a practical matter, um, you largely resolve that by both parties just saying, okay, well, we're gonna, if one party's in, then both parties are in. We're gonna go in because the incentives would make it better. Uh, I'm not being very eloquent about that, but essentially the incentives array, if one party's opted into this system, especially if, whether they're a plaintiff or a defendant, if one party opts in, it just makes sense for the other party to go ahead and be like, well, okay, um, it's your funeral. I think I'm going to win. Or if they're like, hey, I see that you've, opted into this system. Let's go ahead and settle this claim now. Let's move this to mediation now. Um, I think certainly, like, disclosure about your opting into that system needs to be very quick, and there need to be some, for people who are opting into this system, they can go ahead and file their claim to toll any statutes of limitations, but there needs to be kind of a 30-day grace period or something like that before the AOC starts assessing fees um, under this plan. Like, there needs to be kind of like a 30-day window in which you can settle with a litigant who's opted into this system, and not incur any marginal additional cost from the AOC. That's not really part of this proposal. It's not written into this, but I think that's one of those areas where, you run a pilot program and you improve efficiencies and kind of workshop it around. So fundamentally, this is like the initial presentation of this concept. So you can't get into every little detail, but the meat of it is that everybody gets to hire the lawyer that they have the most faith in. Criminal defendants could still have access to the public defender, and nothing would change about that. But if a criminal defendant wants to opt for private counsel, then the same pay upon losing rule would apply. This would ensure that a defendant who wishes to hire a private attorney and is capable of paying attorney fees may do so. And this element would also avoid a windfall for those able to hire a private attorney while simultaneously ensuring the state is not held responsible for the cost of defense for those who do not avail themselves of the public defender system. Defendants choosing private counsel are aware that they voluntarily assume the risk of paying the fees if they lose, akin to a lawful penalty for wrongdoing. If they're acquitted, those costs shift to the state. So imagine a what does all of that really mean? Imagine a criminal defendant says, I don't really trust the public defender. I want to go hire a great lawyer, a great criminal defense lawyer, but I can't really afford that. What do I do? Well, they could use this system. If they use this system, if they use the expanded access to justice system that I've proposed, well, if they lose, they could end up having the costs of prosecution taxed to them at the end. But because at least according to their belief, prospectively from the beginning in their mind, because they're able now to hire the best lawyer that they can find and pay and be able to afford that lawyer, because of that, they're less likely to lose. They're less likely to get convicted. So it becomes a really good risk for them to take. They're able to afford a better lawyer, so to speak, at least in their opinion, one that's better. Um, and so they're more likely to avoid a conviction. But the stakes are a lot higher because if they lose, they end up not just paying for their attorney, but also the cost of prosecution. If they've But think it all the way through. If they've hired the best lawyer that they can get or the one that they most believe in, and that guy's been paid and everything's fine, right? And they still lose, don't you think they probably deserve to lose? I mean, we're talking about beyond a reasonable doubt, jury of your peers, all that stuff. So are we really too sad whenever they lose that lawsuit? No, that feels like justice. That feels like, fines and penalties, which we already assess against criminal defendants anyway. So what's the problem? Any kind of objection on the basis of, well, poor criminal defendants are gonna, have to pay more money. That's a big nothing burger to me, because I feel like you gave them the very best opportunity to avoid that outcome, and yet they still were found guilty by a jury of their peers beyond a reasonable doubt. So I say, if they have big consequences for bad acts, great. Okay, no problem with that, really. And then both plaintiffs and defendants in civil litigation could hire any lawyer they choose without needing to pay out of pocket upfront. That's the big deal here. This provision expands access to legal representation for individuals and businesses that might not be able to afford high quality counsel. And so it's crucial for ensuring equality and equity across civil litigation. Now, again, if a party doesn't want to participate in the system, they would not have to. Nobody would have to. It would always be voluntary. So obviously, lawyers would submit their fees to the AOC. The AOC would review them. They would employ trained legal auditors, attorneys, or paralegals who have expertise in legal billing practices. And then they would review the invoices for reasonableness, just applying the existing test for reasonableness that we already have. And the auditors would also ensure that the billed fees are in compliance with all applicable legal and ethical standards. And then the AOC would flag any charges that are excessive or unreasonable, and it would request additional documentation or schedule a fee hearing. Some of these fee hearings could be administrative. There could be a judge that's hired by the Supreme Court to provide oversight of and just do those fee hearings and nothing else. Right. So you could have someone who's specialized, a judge who's really, really good at just doing that, and that's all they do. And then attorneys would have the right to contest the AOC reductions, but ultimately the final decision by the AOC, or rather by the judge, the Supreme Court employee judge who's assigned to do these fee hearings, would prevail, subject to the requirements of transparency and fairness and so on. The AOC's oversight fee, again, there's kind of a broad range with this initial proposal of 3% to 10%. Would be enough, but it's a surcharge added to each invoice that's processed by the AOC. And it would, that there might even be some variability in the fee charged based on complexity of the case, the number of fee challenges that are raised, et cetera. And it basically ensures that the oversight mechanism is self sustaining and does not unduly burden the state, the taxpayer. And this method also incentivizes efficiency among attorneys, as less efficient attorneys would be likely to incur additional scrutiny. This oversight, and you also could think about the secondary impact of reducing the number of bar complaints, reducing the number of fee disputes with your clients, because you now have this oversight. So, like the benefits, the broad secondary benefits to clients, to society at large, to attorneys. I mean, there's so much that could be written on just this one point. But the oversight fee is analogous to standard court costs or tolls, toll roads for state services, reflecting a rational user fee or an advanced billing system that benefits all litigants and the court system and the public at large and the taxpayer. So benefits all over the place. Indigent defendants or plaintiffs may seek existing fee waivers, or they might rely on public counsel to avoid the surcharge. I'm not real big on that. I wanted to just kind of throw that in there because it's like, well, what about indigent defendants? Yes, maybe they could. I mean, they're for me, the issue is they're not having to pay up front. If they were to lose the lawsuit, if an indigent defendant, despite having the best counsel money could buy, would still lose a lawsuit, then whether or not they're indigent doesn't really have any logical relevance on whether or not they should be taxed with the full cost of the lawsuit. If they're responsible, then them being taxed with the cost of the litigation is justice, regardless of whether or not they can really afford it at the end of the day. And that just, again, it's not a perfect system. It's still better than the one that we have. The person who is found to be responsible for, a bad outcome or whatever, like a bad situation, like you think about someone who breaches a contract, and let's say that the indigent party breaches a contract, right? And the other side is a small to medium sized business. They want to hold the indigent party accountable, but they can't really even afford a lawyer. So everybody agrees to use this system. The indigent person gets a great defense attorney. The medium sized or small business that normally can't afford a lawyer uses this equal access to justice system. Now they can afford an attorney. The two attorneys battle it out. They both do a great job. They're both paid for their work. The justice system's working the way it should. Everybody's got the right counsel. An indigent person turns out to be at fault for breaching the contract. The court enters a judgment, whether or not it's appealed, whatever. In the final outcome, the indigent person gets stuck with a huge bill. They are a poor person who can't really afford all of that, but they get stuck with this big bill for litigation that's not dischargeable in bankruptcy. Whether or not they're able to pay that bill ever, whether or not they're able to pay those taxes ever, has nothing to do with whether or not they were at fault in the contract, in the fee dispute, right? So that's the system. It's a fair system. It's fair because they're at fault. And so, yeah, they ought to have to pay all of that. And because they opted in, the other party opted in, everybody chose to go down that path. You're still free to choose. You're just not free from the consequences of your choice. That's what makes it fair. That's what makes it justice. Justice and mercy are not the same thing. To waive the fee for the indigent defendant wouldn't be justice. It would be mercy. And we don't have a mercy system. I'm not advocating for a mercy system. I'm advocating for a justice system. And it is a more just, fair, and equitable system than the one we presently have. So, is it perfect? Would it be unfortunate for an indigent defendant to get stuck with that? It would be unfortunate for them, but not unjust. So it's not really objectionable, even if it is something that's kind of scary, right? It's a scary thing that could happen to them. So this is, basically an outcome for a loser pays model. And you might say, well, okay, well, what would the loser actually have to pay for? Like, what is it that's getting thrown into the mix of the bill here? Well, obviously, attorney's fees and expenses, filing fees, which we currently, consider part of court costs, that are taxed to the loser in litigation already very frequently, but also deposition costs, court reporter fees, transcripts, expert witness fees, investigative expenses, again, all submitted to the AOC for oversight and review by legal auditors trained to review these things to make sure that they are reasonable and not excessive, and then other miscellaneous fees that are authorized by the court. Because these sums would be non-dischargeable in bankruptcy, as a penalty, they would become, first of all of those invoices are advanced by the AOC. So there is going to be some initial cost, especially like to stand this whole thing up, but they're going to be advanced. Those invoices for all those things are going to be paid on the front end by the state. And then at the end, it's collected from the loser, right? So because all of these things are paid on the front end, the penalty that comes down at the end of the litigation is a true penalty paid to a governmental entity. Therefore, it is non-dischargeable in bankruptcy. It's assessed as a tax that's non-dischargeable. So the victorious party would be made whole. They would not be made to face the risk of non-payment due to a losing party's bankruptcy petition. The AOC or similar entity would collect and redistribute the funds to cover the relevant expenses and maintain the operation of the system. So judgments even could be advanced by the state to the victorious party and then taken out of the hide, essentially, of the loser. This framework discourages frivolous or weak claims and defenses and justly compensates successful parties. So it does make the state a clearinghouse, kind of, for all costs of litigation for the people who opt into the system. Again, not for every litigant, not for criminal defendants who choose to use the public defender or hire their own attorney privately, not for private litigating parties who don't use the Equal Access to Justice program, only for people who opt into the system. This is the way that it would work. So let's consider a couple of simple illustrative case scenarios. Consider a breach of contract claim between a small business owner and a vendor. Under the current system, the small business owner would have to pay legal fees up front, regardless of the outcome, unless the lawyer was going to take it on a contingent fee where they get like a percentage of what they win. But that's pretty rare for most claims. Under the proposed system, both the small business owner and the vendor would be free to hire attorneys capable of handling commercial disputes, and each side's counsel would submit bills to the AOC. If the small business owner's claim was meritorious and they prevailed, they would not have to pay their own attorney. The vendor would be required to pay. If the small business owner lost, they would absorb the full costs of the litigation, thereby avoiding any windfall for an entity bringing a non-meritorious claim. This prospect encourages both parties to pursue settlement if they perceive weakness in their position, thus reducing frivolous claims and promoting more efficient resolution of disputes. In this scenario, the loser pays principle would function to compensate the prevailing party while also acting as a deterrent for weak cases. Additionally, the AOC oversight would ensure that fees charged by attorneys are reasonable. Now, you might say, and I'll leave you to read the white paper. I'm not going to get into the legal analysis in this video because it's all about like constitutional considerations and due process and what about federal bankruptcy law? And I've already kind of mentioned some of that. What about state statutes? Are you going to need to pass new laws to put this system in place? Yes. And for all the legal wonks out there that want to dive into this, it's in the white paper. Go read it. Should courts have authority to do this? What about uniformity across jurisdictions? And what about plaintiffs in one state versus plaintiffs in another state and all that stuff? Yeah, there's a lot to be ironed out, and it's all in there. So I'm not going to get into a lot of the legal stuff. Just like I don't really want to get into the details of what about criminal proceedings and appellate and post conviction proceedings, family law proceedings, what about all of that? There's a lot of, well, what about? This is just a simple proposal. And I've already kind of said everything that I want to say about all those what abouts. Up to this point, and I certainly don't want to get into doing a legal analysis in the video because it's just too wonky. But you can go and get your what about answers largely from the white paper. If you still have questions, please get in touch with me. I'm a very accessible person, easy to get a hold of person. So if you've got questions about this white paper, send them to me and I will send you a thoughtful and detailed response. Just please be polite. If you're rude, I'll just ignore you because nobody wants to deal with rude people. But if you're polite and thoughtful and you've got a real, concern or objection, something you want to engage thoughtfully in this scholarship, then I'm more than happy to give you a thoughtful and polite reply. I do acknowledge that there would need to be some political will, and there would need to be some will on the behalf of the judiciary to implement this system. Like if everybody just wants the status quo and they want to continue on with a system that has crumbling and eroding public confidence, I can't do anything about that. I'm just here to spot problems and present solutions. Um, what is interesting is people might ask, well, why not just do the loser pays? Why do you need the AOC to get involved? Why do you need for legal fees to be advanced? Well, it's simply because there are going to be upfront costs and you have to address in a meaningful way. Well, what about all the people who walk away from meritorious lawsuits just because they can't afford the upfront cost? That there are a lot of attorneys who won't take a case unless they're paid a fee, an hourly fee on the front end or a flat fee or whatever fee, right? It could be an alternative fee. It doesn't have to be hourly. But there are lots of attorneys who just won't work without getting paid, and they shouldn't. Even if we had a loser pays system across the board, even if we changed the American rule at the federal level and we wrote it into the US Constitution that every lawsuit is now under loser pays paradigm, it still wouldn't solve the problem of some lawyers not taking on meritorious claims because there's no guarantee that they're going to get paid on the front end, right? Um, it just doesn't solve that problem. So you need a system whereby legal fees are advanced on the front end to make sure that everybody has the right to hire the lawyer that they believe in, that they have confidence in. When you solve that problem, and then then it's like, well, who gets stuck with the bill at the end of the day? Should everybody just should we keep the American rule and the fees are paid by the court and then everybody just pays back to the AOC their system? No, I think it's better to have that plus a loser pays system. And when you combine those two things, it then creates a more just result by ensuring that the person who is responsible, the criminal who actually committed the crime and is found guilty, the liable party in the breach of contract or the tort claim or whatever, the negligence claim, whatever it may be, right? The responsible person gets stuck with the bill. That's part of what makes it a just system. Like, you did a bad thing, you deserve to have to bear the costs of that. It's not really even about punishment. It's about structuring incentives in society in a way that produces more of the behavior we want and discourages the behavior we don't want. It's incentives. Incentives matter. It's economic thinking applied to the law. So let's talk about the economic impact. One of the biggest economic impacts of this proposal is its potential to enhance the affordability of litigation. You are democratizing access to justice a lot more with this proposal. You are lifting the requirement of paying for legal fees in advance. So the system would open the courtroom doors to individuals and small businesses that previously were deterred by upfront costs. Again, rich people, they can afford to litigate. They can be there all day long if they want to. They can throw money at lawyers till the cows come home. And, they have the money to do it. Similarly, very, very poor people have resources that are available to them. Um, it's less for them, right? Less. If you're very poor, you have less access to justice than the very rich, but there are lots of organizations out there that are designed to help the indigent. The people in the middle get squeezed. The people who have meritorious claims, it's like, oh, it's a good lawsuit, and yes, legally you have a good argument to make, but is it really worth it? It would be if we didn't have to pay the lawyer on the front end. If you didn't have to pay the lawyer on the front end, then it becomes worth it. So this solves that problem. Essentially, any party with a meritorious case could secure representation. We already have, by the way, lawsuits on the books in Tennessee prohibiting frivolous lawsuits and assessing the cost of those to the plaintiff. If a plaintiff brings a frivolous lawsuit, if you're worried about people using this system to do profiteering stuff, we already have a law on the books to deal with that. So that's not really a real objection to this system, because if someone brings a frivolous lawsuit, they're going to end up paying for the other side's legal fees regardless. And this doesn't change any of that. That should happen. If you bring a frivolous lawsuit and you lose, then you should have to pay for the defendant's legal fees. And we already have a law to deal with that. This essentially would mean that any party with a meritorious case could secure representation, since an attorney can be hired without fear of non-payment if the client ultimately prevails. So if you win, you get paid. Essentially, both parties, plaintiff, defendant, they're going to have a lawyer with this system who's going to get paid. Lawyers would want to use this system. Lawyers would encourage their clients to use this system, because even though they have to submit their invoices to the AOC for additional scrutiny and insight, that's well worth it if you reduce the likelihood of a fee dispute with your client and you're guaranteed to get paid. So everybody would want to use the system. And then they would work really, really hard to win, because they don't want their client, the one stuck with the hot potato. So this would provide a significant economic benefit. It allows parties to pursue valid claims without the need for significant upfront funding, because that comes from the state. And then the state is going to get that back in the form of taxes. So the loser pays model, coupled with AOC oversight, creates strong incentives for attorneys to share in the risk of litigation. Attorneys would need to carefully evaluate the strength of each case, by the way. So a loss would mean that they would have to forfeit compensation if as they would be responsible for paying the other party's fees. This is actually an inaccuracy. I included this in an early draft of the white paper. I probably need to go back and revise this and take that out. Attorneys would not forfeit compensation under this plan if they lost. That's just not accurate. So this paragraph under 8.1 on page 21, I will go back and revise the white paper, because that was part of an earlier concept, and it's not really part of my proposal. I didn't realize that was still in there. Well, I guess we're very publicly going through with an editing pass on this white paper, but essentially, win or lose, the attorneys are going to get paid for their work, so you don't have to worry about that. But it's certainly, if a party's client, they're not going to be happy if you lose, right? So there's going to be scrutiny over your billing and your practices, and so on and so forth. So yeah, that's fine. Potential revenue generation for the state. This is not designed to be like a big tax hike on litigation. It's not a litigation tax hike. That's not what this is for. It's simply to compensate the state for services rendered, right? They're doing they're expanding a service that they previously had only offered to a small subset of litigants, just indigent criminal defendants. They're just going to expand that and make that available to people in civil cases. So obviously they need to collect revenues by charging a fee to make that possible. I mean, you can't just otherwise you really would have to raise taxes. You'd have to raise taxes across the board. Doing it this way makes it more like a toll on a toll road, where you are assessing the cost to the people using the system. So I don't think that this program would necessarily be like a true public good, but it is a legitimate state activity. And I think it's like assessing a fee for this is consistent with, again, like the principle of like toll roads, or the court costs and fees that we currently charge for, filing fees. Right now, we have filing fees. Whenever you go to file a lawsuit, you have to pay a fee. You pay it, and it goes to offset the cost of the clerk's office there and the things that they do. So it goes to offset the cost of the burden on the state of providing its services. So that's entirely appropriate, and this would be the same as that, essentially. With the AOC empowered to challenge excessive billing, attorneys would have an incentive to keep fees within reasonable bounds, right? So otherwise, they're going to end up getting a lot of pushback and hearings. You could have like fee shifting. You could have, the AOC even empowered with the opportunity to scold an attorney. The power to scold an attorney who like consistently overbills their clients or something like that. That's kind of beyond the scope of this white paper, but it's interesting that there could be incentives that flow out from the oversight mechanism, and this is just subject to further development of this idea. But the introduction of more cost-effective standards would also lead to the adoption of alternative billing practices, flat fee agreements, especially. I think where you create more certainty on the front end about clients with respect to the overall cost of litigation. For example, if an attorney knows that they could get paid a flat fee on the front end from the AOC, and the AOC, like you think about this paradigm, the pilot program runs, and it turns out hypothetically, after 5 years of running the pilot program, that you know cases within a certain dollar value for certain claims, like breach of contract claims, for $100,000 lawsuits, tend to generate legal fees for attorneys of 35,000 or $40,000, something like that. 35-40% of that $100,000 claim, you know, it tends to be, tends to generate, or the legal fees are about 35 to 40% of the claim amount, right? So it's not causation necessarily, it's just correlation. That typically $100,000 contract disputes correlate with around 35% and legal fees in the range of 35%. So if you have all of those data points, because you got the hourly billing and the whatever, like the existing kind of paradigm, right? You get all of that, and in this hypothetical situation, let's just say that the AOC noticed this correlation, and so they published their findings on the data, or someone filed a Freedom of Information Act request and asked for all the data points, and then they just ran the numbers, and then they published a study, right? The data on all of this is important, and it should be public. It should be collected and it should be public, because then what you could do is you could say, well, your mileage may vary, but in general, for a $100,000 lawsuit, legal fees of $35,000 or $40,000 are within the normal range. That's responsible. I get asked this all the time on the front end of lawsuits. Well, how much do you think it's going to cost? And I'm like, well, I don't know. I mean, nobody can know. I'm billing you hourly, and I don't know how many hours it's going to take. If I knew how many hours it would take, then I could tell you, here's my hourly rate, multiply this by the number of hours I think it's going to take, and that's what I think it's going to cost you in legal fees plus expenses, court costs, court reporters, expert witness fees, depositions, all that other stuff, right? That's all expenses. But in terms of legal fees, I could easily calculate my fee if I knew how long it would take. The problem is I don't know how long it's going to take. And then they always ask, well, how long does it usually take? And it's like, well, why do you think why do you think you're usual? You're typical. Maybe you're an outlier. I don't know. Maybe the other party's an outlier. I don't know. So, we're just speculating here. But everybody wants an answer on the front end. The only way you could really get there is if you had lots and lots and lots of data points, which the AOC could have, right? They could say, under this paradigm, well, for this kind of dispute, this kind of fee is typical. What's a lawyer going to do with that information? A smart lawyer is going to go to their attorney and say, look, you can roll the dice on hourly billing and the fact that you may win or lose, or we can just agree that typically for these kinds of cases, this is what's normally charged, and so I'm going to bill you a flat fee. I'm going to take the risk that I may end up having to spend a lot more time and everything in this than I think I will, but I'm going to take that risk, and I'm going to just charge you a flat fee. Do you agree to that? And they submit it to the AOC, and the AOC looks at that flat fee and they go, yep, flat fee within the range for normal tolerance on that case. Done. No hourly billing. Wildly efficient for everybody. And then the lawyer gets to not worry so much about having to bill hours and all of that stuff, and just producing a damn good result for his client. So efficiencies abound, or the opportunity for increased efficiencies abound, making legal services ever more cost effective, and really also focusing on the value that the lawyer provides to the client rather than the number of hours that they pour into the case. So over time, as more lawyers would tend to, adopt alternative fee agreements, you could even see a shift, perhaps even a rapid shift, away from the billable hour model and towards value-based billing for clients, which is even better, right? So this system has a job to do and a role to play in that trend, which is an existing ongoing trend that's rapidly being accelerated. I think a trend that's being accelerated by the adoption of AI, which is beyond the scope of this video. But anyway, I think there are going to be lots of interesting effects on attorney compensation structures in any jurisdiction where this proposal is adopted. And it will have a market impact on litigation funding. So, because you're essentially offering a replacement for, I think there's still going to be a market for litigation finance. So all the finance bros who are like, no, you don't replace this with, don't provide a socialist replacement for litigation financing. I don't think they really have to worry, because of the existing incentive structures are already there. In other words, this system that I'm proposing is not going after their target market. Like, their target market's going to continue to be their target market. No, very few people, I think, in their target market would look to this system at all. This system is expanding access to justice for people who are not in their target market, who are not, because you wouldn't need a proposal like this if the litigation finance people were serving the people that this would be for. So just, they shouldn't. They're probably not worried. We're not talking about the same market segments, right? So they shouldn't be worried about losing their shirt to a socialist alternative or something. Also, I don't really think it's fair to call this socialist. It's not, but that's one of the expectations I would expect to hear. Social and policy considerations. I mean, honestly, it's just what we've been banging on about this whole time, expanding access to low and middle income parties. And it would also have an impact on court efficiency and caseloads. Initially, the caseload impact would be significant. You would see a significant, because there are going to be lots of people who don't understand it and who are like, "Oh, I don't have to pay a lawyer up front. Well, I've had this lawsuit for a long time that I've been wanting to sue so and so over, but I haven't been able to afford a lawyer, and now I can. Let's go." And so they're going to do that, and they're not going to maybe think it all the way through, right? Hopefully, and lawyers may not think it all the way through. They may be like, "Oh, I get to get paid no matter what. Hey, it's never been a better time to sue somebody because now everybody can afford it. So let's go." But over time, what would happen, and I think it wouldn't take a long time, I think maybe 1 to 3 years, you're going to see this massive influx in litigation. And then over time, as the consequences of doing that become evident, and you see like news reporting and statistical reporting, the AOC publishing reports and trends reports, and all the data and all of that, as you start to see all of the consequences become evident, and people can really see the whole life cycle of the use of this system, what you're going to see is people go, "Oh, it's financially ruinous to engage in this system and lose," and then they're going to think about it twice, hopefully. um, Maybe not. Maybe people would be gambler. Maybe I am underestimating the gambler's fallacy, but honestly, I think that lots of people over time are going to um, see decrease in caseloads over time. Initially, big influx. Over time, fewer lawsuits. So over 10 years, 20 years, I think you're going to see lawsuits drop, but you're going to see the quality of litigation improve and the efficiency of it improve, the experience of it improve. So fewer and fewer people. That doesn't mean that disputes will go down, by the way. It means that people will start choosing alternative dispute resolution more. They will go to mediation, they will go to arbitration. Uh, and the only place that you're going to really see people litigating are where they should. So you're going to see a more just system. You're going to see more justice, more actual justice happening, as a result of improving the incentive structure. So I think this also has broader cultural and civic consequences. Remember, we've got a system with crumbling respect for the judiciary, crumbling confidence in the legal system that we have. I've almost stopped using the term justice system because, while I don't want to believe that you only get as much justice as you can afford, it's hard not to see that. It's upsetting to me. I try not to really dwell on it because it breaks my heart as a lawyer, as a third generation lawyer whose grandfather was a district attorney for 16 years, whose father was president of the Tennessee Trial Lawyers Association, and built a phenomenal uh, civil practice. He did, and criminal defense practice. He did criminal defense and medical malpractice and personal injury. He was a big trial lawyer in his day. He practiced for 19 years, and it was formative for me to grow up in that family culture of extreme commitment to justice. And my dad really believed and believes in justice. My grandfather too, and it was important for them to serve people who were underserved. And my uncle is a lawyer. I have an aunt who's a judge on my mom's side. So you know our family, but both sides of my family have had a long-standing commitment to justice. I consider this to be cultural for me. This dedication. Like, I wrote this white paper not for attention, not for accolades, not for any credentialing purpose. Like, this is an idea that's been like an itchy sweater on my brain for a long time, and I had to get it out. So I'm just sharing this because it's something that I'm clearly passionate about. And I really genuinely believe that this proposal, except for that second paragraph of 8.1, I'm going to have to edit, is a really good proposal on balance. Like, it will have an impact of normalizing the full recovery of legal fees for all for prevailing parties, which creates a more principled and less adversarial approach. Litigants that have borderline claims are going to self-censor. They're going to adopt alternative dispute resolution approaches, mediation, arbitration, whatever, and avoid the potential financial blow of losing a case. So anybody who's like, I don't know about my case, they shouldn't be in court anyway, and this system will edge them out. And critics might worry about chilling effects or whatever on litigation, but I think proponents of this system would argue that meritorious claims would still proceed unimpeded because they're meritorious. They have a reasonable likelihood of success. They belong there, and because they're meritorious and because the person wins, they shouldn't have to pay. And the loser in a meritorious dispute should have to pay. That's more fair. That's justice. The proposed system that I've got in this paper would create a legal environment that's more conducive to settlement, certainly, as both parties would be aware of the potential financial consequences of losing at trial, which would in turn reduce unnecessary litigation and promote a more efficient resolution of legal disputes. So I think this would affect litigation strategy, but only in ways that it should. So in section 10, kind of like in the legal section, I'm not going to get too into that because I don't want to do a deep dive on every section of this white paper. The implementation strategy, I think, number one, needs to be different from jurisdiction to jurisdiction, state to state, certainly, maybe even county to county. I think having different competing pilot programs, like my vision for this would be if Memphis, Nashville, and Knoxville all adopted pilot programs for this, for versions of this and the administrative office of the courts kind of had standardization for their part of it across all three jurisdictions, but maybe the Tennessee Supreme Court allowed for some diversity in the western, middle, and eastern districts of Tennessee to kind of A/B test different ways of implementing and rolling out this pilot program. And then after running it for 3 to 5 years, they could take the one that performed the best and then say, okay, Nashville, you guys did the best with this, got the most efficient results and, best outcomes, et cetera. So we're going to take your approach and we're now going to reform the Western District and Eastern District accordingly. And so now we have a uniform, standardized way of doing this. And we're also going to start rolling it out in Montgomery County and Hamilton County and Williamson County and other counties across the state. So I think that would be, having the pilot programs to kind of test everything and then doing phased rollouts would be a good thing. Obviously, the AOC would grow in its importance and would have more of a technological and data driven approach to both collecting and sharing information as well as processing payments efficiently and doing auditing. So you're going to see, their staff grow significantly, but we're going to have the revenues to do that because of the fees that they're going to charge for their service. So the AOC would need well-trained staff. That means attorneys, paralegals, financial auditors, with clear guidelines for billing reviews, standardized forms, transparent dispute resolution processes. And this is important, especially in the age of AI, where you're like, well, what are lawyers even going to do? The robots are going to take our jobs. And I mean, sure, technology could be part of what the AOC does, but you are still going to need people. And I think it would be great for the AOC to hire a bunch of qualified lawyers and train them and give them the training, the jobs, the skill set to do these kinds of tasks. So I think it could be something that creates jobs across the state, and certainly as you roll this out statewide over 10 years or 15 years, I think a 10 to 12-year rollout statewide is feasible. That would be a pretty quick pace, honestly, if I'm honest. I think that would be a pretty quick pace, but it's feasible, um, subject to how well the pilot programs perform, and how much political will there is to do it. I think as you start to see better outcomes, you know, I think people are going to see the wisdom of adopting this, and they're going to want it more, and there will be demand for it. And it's really not a political football, right? It doesn't like this doesn't benefit any particular party or key demographic or whatever. It's really middle class focused, and it's good for people at the lower and lower middle. It's good for businesses. So Tennessee wanting to be a very business friendly state, this is a really excellent program and reform of the legal system that's pro business, but it's also pro consumer because lots of consumers might have an issue with a business. So it's just good for everybody. It doesn't like this system doesn't really have like a big like we're doing this at the expense of one particular type of person or business or whatever. Um, Even the taxpayer doesn't get stuck with the bill with this. So the only people who really stand to lose big are criminals who are going to get better legal representation under this system. So they get benefits, but if they're found guilty, then they get punished more harshly, and that's fair. That's justice. And then people who are at fault but completely indigent and completely like I don't want to say the words judgment proof because they're not judgment proof. They still have the judgment, um, but who don't have the means to pay the judgment. Uh, but again, kind of like with the criminals, like if they're in the position where they get stuck with it, then that's justice. They ought to. I mean, people who are financially ruined under this system more than likely deserve to be. And again, they might even defer the collections on judgments until all their appeals have been exhausted. So you've got a framework here where like a person who's indigent and financially ruined by having to bear the cost of all the litigation under this system, that's only after like all their appeals and everything, and they've been able to afford a great attorney all the way along through that whole system. So it's hard to say, well, that's an unjust result. That's just not fair. People are getting screwed. That's just not gonna. I mean, that's not consistent with the fundamental principles of the proposal. And obviously, we're going to have in the implementation of this, the funding, the training, the technological infrastructure to really make it work. That's all baked into the cake. It's all well considered as part of the proposal, and it's in the white paper. Um, Lots of people who don't like loser pays generally say that it has a chilling effect on plaintiffs. I don't think that's the case here because a genuinely meritorious claimant has a fair likelihood of winning and therefore avoids, the costs. So the only people that it really has a chilling effect on are people with frivolous or kind of borderline claims. They're still going to be able to access the justice system as it stands. Nobody's making you use this system. Nobody's requiring this for anyone. It wouldn't be a legal requirement. It's an access to justice program that people voluntarily could choose. So if we were mandating loser pays everywhere, always at a constitutional level, well, then yeah, that might be a valid objection. But in a voluntary pilot program, not so much. Or even if it's not a pilot program, permanent program, a voluntary program that expands access to justice, that's not really a real objection, is it? Because we're not requiring it. And then you might say, well, some people might become overly risk averse. Well, only the ones who voluntarily opt into the system. So that's kind of a weird objection, especially if the outcome's uncertain, but the outcome's always uncertain in litigation. The the person who has the most meritorious claim isn't always the person who wins. So that's why we have appeals. So sometimes you have to file a Rule 59 motion. Sometimes you have to file a Rule 60 motion. Sometimes you have to file an appeal because sometimes the judge gets it wrong. All right. So that's just what you have to do. And does this have an impact on risk aversion? Well, I would say that it makes appellate work more affordable. Appellate work's extremely expensive, but it would make it more affordable. I think it takes away basically the cost barrier to justice. So if people are getting more risk averse, then what that really implies is they're being more honest about the volatility involved in the system, and they're being more honest about the fact that they don't have a real clear cut case on a clear cut path to victory. So, and then there are the worries that I alluded to before about bureaucratic overreach. I mean, obviously, mission creep is always a concern when it comes to the government. Opponents could claim, especially I think about libertarian opponents to programs and proposals like this, who might claim that allowing a government office to review private attorney invoices threatens the independence of the bar. Yet we already have judicial review of fees in a lot of contexts. Courts regularly review petitions in class actions, bankruptcy proceedings, statutory fee shifting contexts, etc. So there's precedent for that already. We're just expanding this, and we're expanding it in a way that's totally voluntary to the claimants. So again, it's kind of a nothing burger objection, but it's one that I would still anticipate hearing, especially among people who only engage with this superficially. The proposed system would include mechanisms for attorneys to challenge fee reductions imposed by the AOC, so they're entitled to due process on their, the review of their invoices. So that's fine. The oversight's really intended to protect against abuses, not to infringe on the rights of attorneys. So the AOC, which would be, part of or reporting to, depending on your jurisdiction, the judicial branch would act as an administrative arm of the courts to ensure proper and ethical billing practices. There's already ethical oversight by the Board of Professional Responsibility. So it's not like there's presently no oversight of attorney billing practices. It's just that you have to file a bar complaint, you know. Um, so this would increase the number of data points available both to the Board of Professional Responsibility, to the Supreme Court, and all of that about what is actually normal, which would actually make their jobs a lot easier in terms of deciding what is and what isn't a reasonable fee. And it would perhaps even trend towards codifying existing ethical requirements for attorneys a little more concretely. People might say, well, if a lawyer's guaranteed to, get paid regardless of the outcome, aren't they just going to charge a bunch more money, and isn't that going to cause fees to skyrocket? Well, no, that's what the AOC's scrutiny is all about, is preventing exactly that. So allowing them to curb abuse will help. Um, so I think that oversight will neutralize that kind of inflation, especially because you also have judicial review and that sort of thing. Um, there are lots of people, and I've mentioned the argument already many, many times in this video, who would be afraid of the unfair debt burdens and the abuse, and the risk of paying the opposing side's fees. Um, does aim to deter frivolous or weak litigation. So we want to create a level playing field to provide an incentive for responsible conduct without creating undue hardship. I think relying on a penalty is intended to align with that goal. We certainly are okay with it in a lot of other contexts. So my question would be, why not this one? And then you might say, well, again, in a criminal defense context, is it really fair to get to hit a convict not just with all the other, consequences of his actions, or her actions? Is it fair to also charge them with the cost of prosecuting them? I'd be like, yeah, it absolutely is, because they got the best attorney that in their estimation, the best attorney that they could afford, or I mean, that they could hire, and they didn't have to worry about having to pay him on the front end. So, criminal defense attorneys are going to get well paid. They're going to, it makes more people want to be criminal defense attorneys, because they don't have to worry about not getting paid. So again, expanding access to justice, increasing both the supply of criminal defense attorneys, but also increasing, um, access to them for each individual defendant. So they still have to be convicted beyond a reasonable doubt by a jury of their peers. So you've got a higher confidence system, better quality lawyers, and more of them. So yeah, if those people are still getting convicted, I'm going to go ahead and say they probably deserve to be, and I'm not real worried about all of that. Um, it doesn't eliminate every inequity or unfairness. I will say that there still will be unfairness in the legal system for criminal defendants, right? Like people who are like, well, judicial system is biased against the legal system's biased against this demographic or that demographic. Well, studies have shown that, for some crimes, some demographics get convicted more, while for other demographics they're more convicted more frequently, and receive harsher penalties for longer crimes. Like, white people in white collar crimes tend to get higher conviction rates and stiffer penalties, whereas for drug crimes it tends to be people of color. So, who get more convictions and stiffer penalties. I mean, that's just the statistics. That's not even controversial. It's just go look at the data out there, right? There's nothing like racist about observing that that's the reality. What is bad thinking, is to say, well, the justice system as a whole, in general, is biased against these kinds of people, whatever, one side or the other. That's just not true. It's There is inequality, there is unfairness, but it's not uniform. It's not uniformly distributed unfairness. It's like the family law, uh, courts, the family courts are unfair to men, right? They are. Men get a bad rap. They get treated badly by family courts. So that's just the way it is. That there's a big need for fathers' rights attorneys. There's a big need for like large scale reform of family courts, so that men can be treated fairly in a family law setting. That's just I mean, again, it's not even really controversial. Anybody who's honest knows that that's the truth. And anybody who looks at the statistics on it knows that that's the truth. And even modern trends are starting to pick up on that and acknowledge that, where in more progressive jurisdictions, efforts are being made to prevent good fathers from losing their children and stuff like that. So, um, yeah, the justice system, the legal system is not fair, and it will never be perfectly fair. It will always be an imperfect system because it's complex, it's highly developed, and any complex, highly developed system is going to have inefficiencies and inequities. The question is not what would the perfect system be, or will this proposal give you a perfect system? It won't. So if you're looking for perfection, sorry. Hilderland said, "What has always made the state a hell on earth is precisely that man has tried to make it his heaven." This is not a utopian proposal. This is a proposal for something that's marginally better, that will give us a more just, more fair system and expand access to justice. So, in short, to close it all out here, this white paper presents a proposal for a transformative legal reform. I've envisioned a legal system in which anyone, regardless of standing, or economic standing, can access high caliber counsel. By converting litigation costs into a post adjudication expense for the losing side, and by implementing a court supervised fee system, this model endeavors to neutralize the historically prohibitive effect of expensive legal representation. The aim is to ensure that access to justice is not merely a function of wealth, but rather a function of the merits of each case. It's a meritorious system, a merit driven system. The ultimate goal of this proposed system is to fortify the rule of law through equitable access, meaning less violent society, right? That's what we want. Less violence, more faith in the legal system, ensuring that no litigant sees justice foreclosed for want of financial means. This system, if thoughtfully enacted and carefully administered, could create a more balanced and transparent marketplace for legal services. Like any broad reform, it does require legislative action, pilot testing, training, and ongoing assessment. So, like any broad reform, it's not special, right? Just because it's the law doesn't mean it's special. It is a broad government reform, and like any of them, it will require legislative action. It will require people doing what they're supposed to do, right, to implement this thoughtfully, and it will require people to continually assess and improve on the system. Still, the anticipated benefits, a fairer, more efficient judicial process, expanded social trust in the courts, a more rational approach to litigation financing, especially in the middle of society and towards the lower end, the lower middle, are substantial and they outweigh any potential drawbacks that I can foresee, at least. So, this is not merely a theoretical concept. This proposal could fundamentally transform the legal system and help ensure that all citizens have equal access to justice. No system is perfect, but this approach reduces taxpayer burdens. It promotes meaningful access to private counsel, and it deters frivolous litigation through clear, enforceable penalties for losing parties. So the goal is greater fairness, improved confidence in defense quality, and a balanced way to finance legal representation. I wish I could tell you all the stories. I wish I could tell you all the people who've come to me over, almost 13 years and brought me cases that have been heartbreaking. I have cried with them. I've counseled them. I have um, coached them, and I've turned a lot of them away. And I sleep really well at night on that issue. You know, it doesn't bother me. I don't feel like I'm a bad person. I don't feel guilty for turning people away because I'm not responsible for this system that we have. I just operate within it. I didn't create it. I don't like it. But what I can't do is sleep well at night knowing that there's an idea up here for how to fix it that I just didn't tell anybody about. I'm not saying I have the solution. I'm saying I have a proposal and it's a good one, except for the second paragraph of section 8.1, which I'm going to go back and edit after as soon as I get done recording this video, right? I'm not perfect. I make mistakes. I even made a mistake in writing this white paper, right? It's not a perfect proposal. Please don't ignore it because it's not perfect. I would ask you to get this white paper into the hands of a congressman, into the hands of a senator, into the hands of a Supreme Court judge, into the hands of a law professor. Um, to the local bar associations, I say, please read this. Please consider it. Please think about it. Remember why you went to law school. And maybe it was for purely selfish and financial reasons, but I don't think that's true of most lawyers. I think most lawyers wanted or have developed an appreciation for a more just and fair society. I think every lawyer who's ever tried a case in a courtroom knows and has felt that it's a proxy for violence, that there's this baseline understanding that, if we didn't have this system, this legal system, it would be people coming to blows. They would be fist fighting or coming at each other with weapons. The alternative to this is violence. And whenever we have a better legal system, we have less violence. And when our judicial system crumbles and people lose confidence in the legal system, we have more violence. No one has to bring up um, riots in the streets. Nobody has to bring that up. No one has to bring up the outcomes of conflicts between the police and the targets of their law enforcement efforts. No one has to go into all of that because it's all really fresh and top of mind for anyone who's just been awake and alive and paying attention for the last 20 years. We've all seen it. And if people believed that the system was more fair, that they could go and if they have a lawsuit, they can, well, of course I could just go hire a lawyer. I know I don't have to pay them on the front end. It's cool. Like if I need to go file a lawsuit to resolve my differences with somebody else, I don't have to take anything to my own hands. I don't have to threaten them. I don't have to get violent. I don't have to get ridiculous. I don't have to worry about not being able to have a lawyer. I'll just go hire a lawyer. I'll pay for it through the Access to Justice program. They'll resolve it for me or with me, right? We'll go through the courts, we'll work it out, we'll put it in front of the judge and let them decide. And they'll be able to do the same thing. And whoever has the best case here, based on the facts and the law, will win more often than not. That's the way it should be. That's peaceful. It's less angsty, angry, violent, right? Tumultuous. It comes from that is a place of security, of abundance in our legal system, and that's what I think we all really want in our society. That's the society we want to live in, I think. And yeah, there are going to be some people who are going to get crushed under this system, but mostly the vast majority of them deserve it. It's justice. It's a justice system. So this proposal doesn't just improve access to justice, it actually gives us more justice. I think it's worthy of your consideration. I've put a lot of thought into it, and there is so much more to this idea than I could probably write about how to implement this system for the rest of my career until I retire. I could write about this, I could publish more papers about this, I could do more and more legal scholarship, I could give talks and CLE and all of that. I won't. Unless someone comes along and asks me to, I probably won't. Because this is probably all I can do by myself. Write a paper like this, or maybe a couple more. If I have a really good idea for diving deeper, another really great idea, then maybe I will write another paper, an additional and further insight on this expansion of access to justice. But unless someone else shows me that they care and expresses an interest and picks up the white paper and wants to talk about it, um, then this is probably all I can do. I mean, no one's asking me to run for office. No one's asking me to run for Congress or be a senator or even be a judge. I'm just one lawyer who gets a lot of calls from people who have good claims, who've been falsely arrested or who've been disparaged, who've been the victims of defamation or who've been wrongfully terminated or who've been, you know, um, the victims of fraud, who've been the victims of various uh, other parties' negligence. It's not their fault, but they also can't afford to do anything about it. And that makes me sick. It makes me sick that people have to give up on meritorious legal claims just because they can't afford a lawyer. And good for us for having an indigent claims system for indigent criminal defendants. But is that the best we can do? Is that the best we can do? Is that where justice ends with the Sixth Amendment as currently implemented? Are we doing our part? Are we doing enough? I don't think so. there's a better idea out there, and at least I think so. So I want someone to pick up on that idea, pick up the ball. Like, here's the ball, here's the torch. I've lit the torch, and I've run the first little leg of this race. I'm willing to hand it off and cheer for you. I'm willing to be a part of whatever somebody wants to build around this idea, whatever movement or momentum or organization people want to build around this. But please don't let it die in the dark. That would be a shame. Uh, that's my heartfelt plea. This is my whatever Jerry Maguire moment or whatever. That there's a better way. There's a better way. And all it really takes for us to have a better legal system is for people to look at ideas like this, to thoughtfully consider them, and then just try. And you know what? If it fails, it fails. But try, at least try a little bit. Um, get the word out there, start a conversation, spread it around, and see what happens. Maybe nothing, maybe something. Maybe nothing in Tennessee. Maybe somebody will hear about this in a jurisdiction in Colorado or California or someplace like that, and someone will pick it up and do something with it there. And all it takes is one jurisdiction to try and to get a good result, and then share that result and build momentum from there. It just takes a little bit of thought and a little bit of effort. Actually, let's be fair, a lot of thought and a lot of effort, but I'm doing my bit. All right. I have a white paper on Substack that I need to go edit right now. Look in the chat, or not the chat, the post accompanying this video. I'll go through and put in links after I get done doing this live stream, and I'll just add in links to the white paper on Substack. If you want a PDF copy of it or something like that, hit me up and I'll be more than happy to send it to you for free. All right. Thanks for tuning in, for listening to my idea. I did not mean to go 2 hours with this, but here we are. I feel better. I feel like I've been able to finally like scratch the itch, right? But because this idea really has been like an itchy sweater on my brain for, I don't know, a while, for as long as I can remember. But yeah, access to justice, it matters. It matters. And I think it will make society better if we do something like this. Thank you again for tuning in and for your attention and your thoughtfulness. And I guess stay tuned for more random stuff like this. All right. Have a great day.